This is Jeb Butler and Tom Giannotti of the Butler Kahn Law Firm. We're here to talk today about a $2.3 million settlement our firm just achieved for our client in a pedestrian collision case. And Brother Giannotti going to tell us what the facts were.
Yeah, so this case started out on Mother's Day of 2022. Our poor client is a woman in her early 70s, was out on a morning walk on Mother's Day and unfortunately was struck in a crosswalk by an inattentive driver. You can see the intersection here on the screen behind us. This is the intersection where the accident happened. Our client was walking in that crosswalk you see. She had just been out walking on the sidewalks and was about halfway through the intersection, and the driver stated to the police that she did not see our client until it was too late, until the collision basically, which to us is an admission of that you weren't paying attention, right? So you have the police report here. You can see the driver is suspected at fault.
Zoom in on that a little bit.
Oh yeah.
Give me something to do here.
And then of course you have the section of the report that summarizes the officer's narrative that's highlighted. The driver again stated that she did not see the pedestrian until the collision. So that told us that we had what we call a clear liability case. And I guess next we turn insurance.
And part of the reason for that is if the driver doesn't see the pedestrian until the collision, that tells us they could not have been looking ahead.
Right.
Was what part of the car struck the pedestrian?
It was the front of the car. Actually, our client went over the windshield, sent tumbling over the hood and the windshield.
So if you're hitting something from the front of your car, you didn't see it till you hit it, that tells us you weren't doing a great job of looking where you're going. And it seems unlikely that our septuagenarian, 70-something-year-old client was like sprinting across the crosswalk.
No, she was actually wearing a reflective vest too. It was daylight out at this point, so it wasn't dark to where she'd need it, but she always made a habit of wearing that for extra visibility. But of course, that told us even more that how you didn't see the pedestrian who's wearing a reflective vest until
Right.
your car basically hits her. So Jeb can talk about what our kind of initial workup was in terms of finding insurance, which is an important thing in any car accident case.
Yeah, of course. So our first, we learned the facts of the case, and at the same time, concurrently, we're looking for the insurance information because that's going to matter a lot. And something that we're seeing more and more, Tom and I were talking about this in a different case earlier today, happen, and that is that the insurer hides some of the insurance. And this is really quite bad. Like, that shouldn't happen. An insurance company is supposed to care about protecting their insured. If I have an insurance policy for Tom and Tom's been paying me premiums for it, then when Tom gets in trouble and someone's trying to sue him, I'm supposed to be like, okay, this is the amount of coverage we've got. And the insurance company might pay it all or they might not, but they're supposed to at least tell you what there is. I mean, they're required by law to do that. But what we're finding is, kind of disturbingly, sometimes now they don't. That's particularly problematic with disreputable insurance companies. And I will call names. By disreputable, I'm referring to Allstate, which has become notorious for bad habits among the members of our profession and judges. I've heard judges complain about Allstate from the bench. But anyway, off that soapbox. So what we have here on the screen behind us is a form we got back from Allstate. We requested the insurance information, all of it, under Official Code of Georgia Annotated 33-3-28. We get this back. And here we have a certification. Tom has been nice and removed their name from it. But someone is telling us here in this nice, letterhead certification that they're telling us all the insurance that's out there. Okay, fine. That's what we asked for. So let's see what they actually gave us. We cruise down here and we get this declarations page, this coverage page. And here they tell us we got $300,000 of insurance. Now that's better than the state minimum of $25,000. So most personal injury lawyers say, okay, that's good news. And they probably try to settle the case for that amount, thinking that's all the insurance that's out there. And most clients never find out different, particularly where Allstate is pretending they're telling us about additional coverage, here highlighted, but that they don't say anything applicable. The uninsured motorist doesn't apply here, so they're telling us that all it is $300,000. Now, we don't stop there for some case-specific reasons, even though, our client was badly hurt enough that clearly $300,000 should be paid and wasn't even going to be enough to compensate her. We filed the case anyway. And lo and behold, there's a whole new policy they didn't tell us about before called an umbrella policy for $2 million. We didn't find out about that through Allstate at all. In fact, our client's insurer, USAA, happened to mention it to us, which is how we knew about it. So we wrote a stern letter to Allstate, and they got their act together a little more promptly. But it turned out there was not $300,000 of coverage in this case, but $2.3 million. And that's an important difference because not every case is always worth the policy limit. Just because the limit's out there doesn't mean you couldn't collect it. But in this case, when you combine a great client who a jury is going to like with real injuries that Tom's going to tell us about, and to toot our own horn a little bit, I mean, hell, we are making these videos. We worked the case up for trial and did a good job, and people know that we're serious lawyers. So you combine those three things, you can get good results. But now I'm ahead of myself. I'm supposed to shut up while Tom tells us what the injuries were.
Sure. Well, the biggest thing for our client was that she broke both of her arms. That obviously makes life very difficult. She had to have surgery at the hospital. She was taken, of course, from the scene by ambulance to the hospital where she had the surgery. Her surgeon operated on one arm, and then the next day basically did the next arm, and she had metal hardware inserted in both of her arms. The bone that was actually broken primarily is called the femur. That's the humerus. I apologize, the humerus, and that's the upper arm, the bone that's up here in your upper arm. But because of where the fractures were and the extent of them, meaning the bone was just broken into a bunch of different pieces, and it was close to our client's shoulder in one arm and close to her elbow in the other arm, which created all kinds of complications. It was a very rough and long road to recovery. She did physical and occupational therapy for about a year after the accident. And actually we have a nice, pretty illustration that we made for trial.
There you go. I was trying to help you out, but I couldn't find it.
Well, this picture is worth a million words, really. I mean, I could sit here and talk about it, but this is, that shows you the fractures to her humerus and how bad they were. And so that's,
I'll see you in a little bit.
That's really close to the shoulder, which creates all kinds of other problems.
So we do this, do this a good bit in cases where the injuries sort of merit it, or where it could be helpful. But you have, the actual x-ray, and then our firm retains someone to do a formal medical illustration that we'll get a doctor to ratify and make it admissible so we can explain to the jury what's going on. So that's obviously the right side, and then the left side we can see the x-ray and then the illustration. A lot of times our clients will say, they'll hear me say things like that, talk about explaining something to the jury, and they'll say, dude, I don't want to go to trial. I want to settle the case. But it doesn't matter. Your lawyers, if they're good, should be doing the same work whether the result's going to be a settlement or a trial, because if you're serious about it and you work the case up for trial, then an insurer knows you're serious and will often, not always, but often, pay a fair number to our client. But if you have a lawyer who will not prepare the case for trial, then the insurance company doesn't have to do that. They know they can just lowball all day long, and it's never going to matter because the lawyer's never going to force the case to trial, so they don't have anything to be afraid of. So that's why we do things like this. This case settled, but the money we spent on getting these diagrams done is money well spent because it alarmed Allstate sufficiently to have them offer a number that our client was willing to accept. I think I kind of butted in on you, Tom.
No, that's all 100% on point. I mean, they're not cheap to spend the money to work the case up and the time and the effort that's involved in that, of course. and we think it shows. And in this case, it paid off, and our client was able to avoid having to go through a trial after everything else she'd been through. Again, she had been through basically a year of therapy, not only physical occupational therapy, but also what we call cognitive therapy, because she also suffered a traumatic brain injury, a head injury that was a result of we believe, her nose hitting something. She actually lost consciousness for part of this collision, so she wasn't really sure what happened, but the doctors said, well, you have a broken nose and evidence of a head injury, and she had some cognitive problems after that, difficulty remembering things, just kind of general confusion, which is classic symptoms of what we call a TBI, or traumatic brain injury.
Right.
So thankfully, that with that additional therapy, she was able to make not a full recovery, but thankfully things were not worse, and we think a jury would take those injuries very seriously, particularly with the evidence that we developed to show a jury. So ultimately, and Jeb, you can talk about kind of what went into the timing of our limits.
Allstate thought so too, eventually, once we figured out what the full limits were. And we waited until we felt like we had the case ready to go. It was clear we had the case ready to go. And we felt like our client had reached a point, approximately what we call MMI, or maximum medical improvement. That is, she'd gotten as good as she was going to be. Like, if you're in your 70s and this happens to you, you're never totally back to normal, but she got as close as she was going to be. So we knew where things stood. And we offered then to settle the case for the full policy limits of $2.3 million, which is an aggressive ask in a case like this. The medical bills were, not all that high, comparatively speaking, but, we had a great client. We'd done the work, and people know we're serious. So Allstate paid the money, and we ended up with a happy client and a good pedestrian accident settlement.